Thanks very much for the opportunity to join you today. I ceased to be a commissioner in December of last year, so I'm no longer constrained by the burdens of public office, but burden commissioners down from saying what they think. So I am still active in this area. Since leaving the Commission, I've actually become a director of the Western Community Legal Centre in Melbourne. So I'm continuing to be actively engaged in this area of public policy. It's just over 2 years now since the Commission transmitted to the Treasurer, the then Treasurer, Mr Hockey, the report. And it's, I think, interesting to note that it took some 19 months for the Attorney-General of the Commonwealth to respond to that report. The Commission made 83 recommendations, of which 50 in total or in part are directly relevant to the Commonwealth. Some of the others, some recommendations are quite specific to an individual jurisdiction. Others relate to bodies responsible for legal training and so on. But of the 50 recommendations that in whole or part apply to the Commonwealth, the Attorney-General could only see in those 19 months to get his mind around 17 of them. So there is a huge range of recommendations relevant to the Commonwealth that it has yet to bring its mind to. Beyond that, of course, as I said, there is a large number of the recommendations which relate in part or whole to one or more of the subnational jurisdictions. It's interesting to note that Victoria has embarked on a very extensive public investigation of its legal assistance sector in particular, and the ACT government has also done some work at looking at the Commission's recommendations. I think it's really important to understand that this wasn't a piece of work that was undertaken by my colleague Angela McRae and I, supported by Dominic Lowe and her very good team of research economists in the Canberra office of the Commission. We received 334 submissions in this public inquiry, both in relation to the issues paper and the draft report. We received formal evidence which is on the public record. I think there was a small piece that was made confidential. But we received evidence from over 100 witnesses in every capital city in the country. So this is probably the most inclusive public investigation of the civil justice system. It covered a huge range of areas. I mean, the most popular debate material that's come out of it has been around legal assistance. Although I did develop some notoriety with members of the judiciary about the Commission's views on cost recovery for courts. But in relation to the legal assistance work, I just make two observations. In hindsight, the Commission could have done a better job if it was asked to investigate legal assistance in the whole rather than legal assistance for civil matters. The two are intimately related, and the people who have the most civil need often have criminal issues, and how they end up in the formal legal system is a function of disadvantage, and quite frankly, most people who aren't legally trained really don't quite understand the difference between the civil and criminal jurisdiction. The other thing I think is important to know, to keep in mind with respect to legal assistance, is that the legal assistance community has latched on to the Commission's $200 million recommendation for dear life, and I absolutely understand why that is. But that recommendation, that $200 million recommendation, is not the Commission's view about what is needed.
And what would that be?
What should have been provided immediately, and the Commission sets out a series of propositions, a framework, if you like, for the development of a decent, robust in terms of policy and equity, funding model for national legal assistance. And I think it's fair to say, despite some reference by the Commonwealth Attorney, that no serious progress has been made in in pursuit of that, perhaps with some work that's being done about improving data collection in community legal centres. So that's probably all I'd want to say up front.
In terms of the value and significance of the legal assistance sector, including community justice centres and legal aid systems, the Productivity Commission made certain findings, didn't it, about the efficiency and effectiveness of those sectors. Is it your view that they need much more than the 200 million that is being spoken about?
Absolutely. The 200 million number, how we got to 200 million is outlined in one of the appendices of the report, but it is essentially this. It went to a reversal of most of the cuts to community legal centres, which the government has reversed at least temporarily, except with those two environmental defenders offices, which the government seems to supposed to have an ideological objection to the existence of. It went to raising the means and assets tests for legal aid by 10%. Yeah, so literally all we did was move that up and see who would be caught and what the additional demand would be. And then for both, as I say, the assets test and the income test. And then the third bit of money was to fund some quite specific measures that related to family and domestic violence. And they came to several tens of millions of dollars. I think it's fair to say that absent Rosie Batty's advocacy in the family violence space and the timing of her being Australian a year and the perception that community legal centres do nothing but family violence work in the media, I think, absent that coincidence of events, I'm not sure that the CLC funding cuts would have been temporarily reversed. I think that was simply community pressure. So that's how we got to 200 million. It wasn't an assessment of unmet need or anything of that. We know there's a lot of unmet need. We know that, the legal assistance sector runs on the smell of an oily rag. There's no sense that there's people in luxury offices and, they're replacing computers every 12 months. There's no productive efficiency to be found. There's no fat to trim. But the reality is that if you are not in receipt of substantial welfare payments, you will not get legal aid. Mm-hmm. And to be quite frank, you'll fail the means test unless you're on welfare, and even if you are, you may not get it on matter basis. There are a lot of matters which simply don't get aided. Putting aside the problems that have been experienced in family violence about women confronting, and it's typically women confronting men who have been violent towards them, and the man being represented or not represented, and how the legal aid rules work in various jurisdictions, a problem which has now largely been fixed.
So, Ed, do you have some questions for Warren?
Yeah, I wonder if you can comment a bit on the interaction between legal problems, and particularly for disadvantaged people, and problems that might fall within other portfolio areas within government, particularly areas like health and housing and so on, and how that impacts on overall costs to government. And I guess what I'm driving with that is that we have a fairly clear sense that if you address a legal problem at an early stage, not only is that a good outcome for the individual because you save them a lot of personal trauma, but you also save the legal problems within the Attorney General's portfolio. You save some costs there, but they have a flow-on effect into other portfolio areas. I wonder if you can comment on whether that is right, and if so, what you were able to kind of find about that.
Look, legal problems like many other issues that disadvantage people experience are not like red wine. They don't get better with age. And it's the Commission, and a number of the people who actually worked on the inquiry at the Commission have been involved in the Commission's long-standing work on disadvantage. And the people who suffer from chronic, entrenched legal issues tend to be people who are disadvantaged. If you look at the income distribution of people who seem to experience legal challenges, it's interesting. The distribution's actually bimodal. There's a larger peak for people who are poor, and then there's another peak for people on a middling-sized income who, when you try to unpack the data, seem to be, for the want of the word, recidivist, dodgy business people. But they're more wealthy than the poor. And it's the first category that I think we're most concerned with. People who have mental health issues, people who have addiction issues, people who are homeless, people who are poor, get involved with the legal, get caught in civil matters, typically because they can't afford to live. So they don't pay their rates, they don't pay their phone bills, they embark on petty shoplifting crime because they need to have things to live. They eventually then their social their what are particularly in failure payments of bills are often concomitant with minor crime. They may have issues with, particularly men may have issues with alcohol and violence towards their partners. So they end up in breach of restraint orders, they end up in the criminal justice system, they get fined, their economic circumstance deteriorates, they have a criminal record, they can't work, they are unwell, they're a burden on the public housing system to the extent they can actually access it, they're probably more likely to end up homeless. So these and we know that the people who experience and there's some data presented in the report, but a lot of these people who are continuous users have multiple interrelated, complex civil and criminal legal issues. And of course, because of the relative shortage of funding for legal assistance, because of the application of DTRIC and how that impacts on the distribution of particularly legal aid money, the ability to legally assist these people at the start, when they might first just have an unpaid bill or something like that, is not there. And they're vulnerable. They're vulnerable to scammers and all sorts of things. And this just leads to all the social costs that are well documented and well understood in relation to disadvantage. Now, part of the trick here is how do we get at this? Well, quite often, Indigenous people are obviously a special subcategory of this, but they even have more chronic problems because of their interaction, particularly with the public housing sector in some jurisdictions. One of the things that we think is actually quite important, and the states do this to varying degrees, is to actually train professionals who work in, we'll broadly call them community services, to at least identify when one of their clients has a legal problem and then refer them off to a competent legal or paralegal practitioner who can help them with it. Now, in some jurisdictions, there are compulsory basic legal training requirements. There are some hospitals now, I think Victoria, where there is a community solicitor. The CLC's basically put someone through the hospital every now and then. Now, often that's in relation to family violence issues, not. But the point is that we know that part of the problem that people have when they're developing legal problems is realising they don't actually have one. So if we can help people who are in contact with them, and I mean, I know this is difficult to understand, but a lot of people find lawyers scary. And there's this presumption that if you have to get legal assistance, you've done something wrong. There's a stigma to it. Yeah. Whereas if you're involved with some sort of healthcare, that's much less stigmatic. So they're the sort of things is we've got to do two things. We've got to help people understand when they've got a legal problem. Now, the part of that's community legal education, but quite frankly, the sort of people with whom we are talking about, many of them are not accessible through the normal sort of civics education. So we've got to have the people who are helping the disadvantaged develop decent legal skills. And if you're particularly in remote rural areas and country towns, that's pretty hard.